Well, welcome to the channel, viewers. I'm Dr. JWA, theologist. This is a pretty important situation. I've tried to, despite the shadow ban on my channels, get this message out. I've come up with an outline that I think might help for anyone that wants to take the time to listen. Our prayers are for the people that have been affected by the 2013 law adjustments. I'm going to disappear into the background and present Australian sex identity law crisis exposed. Viewers, when Parliament altered the foundation, this outline develops the argument from an opening prosecution brief into a full legal, political, behavioural, constitutional, moral case. The central claim is not that one person's private motive can be proven. The stronger claim is that Parliament altered a foundational legal category without adequately preserving women's sex-based protections, creating foreseeable conflict, harm, litigation, institutional confusion, and public distrust. Australia is now facing a question it should never have had to have allowed to become legally unstable. What is a woman? For most of the nation's legal history, that question did not require ideological mediation. A woman was an adult human female. Female spaces existed because females existed. Female sport existed because females existed. And female privacy existed because females existed. Female vulnerability, dignity, safeguarding, pregnancy, motherhood, domestic violence protection, bodily privacy, sex-based legal recognition, and rested on one intelligible foundation: biological reality. Then Parliament altered the legal structure. The change was presented as inclusion, but the consequence was collision, because one gender identity was placed inside sex discrimination law without a clear hierarchy preserving biological sex protections. The law created a rights conflict machine. And the result is now visible, and I'm sure you would agree. Women are fighting through courts for protections Parliament should have preserved. Service providers are exposed to legal risk for recognising biological sex. Public institutions are completely confused. Politicians are now attempting repair, and Australians are being forced to ask whether law still recognises reality, or whether reality must now ask permission from law before it can be spoken. Viewers, this presentation argues that the 2013 Sex Discrimination Amendments introduced a contested ideological category into a legal framework originally structured around biological sex. And the failure was not merely linguistic, it was architectural. Parliament did not simply add protection. It destabilised the protected category of woman by failing to preserve biological sex as the controlling legal foundation for female-specific rights. And that created a degeneration pathway. Ideology entered the law. Law altered definitions. Definitions destabilised protections. Protections became negotiable. Negotiability produced conflict. Conflict produced litigation. Litigation produced victims, and now Parliament must restore the structure it has damaged. Viewers, the necessary remedy is clear. Biological sex must be restored as objective, binary, and operative for sex-based protections. Women and girls must regain clear legal protection in spaces, sport, services, prisons, shelters, bathrooms, change rooms, and female-only settings. And those harmed by defective, right-conflictive law must receive review, remedy, and where proven, compensation. Viewers, we move into point 1, the original legal construct. Before 2013, the Australian Sex Discrimination Law, operated on a coherent foundation. Sex meant biological sex. Male and female were not floating identity categories. They were embodied realities. The original legal structure assumed that biological sex mattered because real-world differences mattered. Women's legal protections were not arbitrary privileges. They were recognition of material realities: female biology, pregnancy, sexual vulnerability, bodily privacy, physical differences, sex-based disadvantages, and historical discrimination against women as females. And viewers, listeners, this matters because law does not protect what it cannot define. If woman becomes unstable, then women's rights become unstable. If female becomes negotiable, then female-only spaces become negotiable. If biological sex loses operative force, then protections built on biological sex lose force with it. The original construct, viewers, was not perfect. No law is. But it was intelligible. The public could understand it. The institutions could apply it. The courts could interpret it. Women could rely upon it. A female-only space meant female only. A woman's sporting division meant female. A woman's refuge meant women as biological females. A pregnancy protection attached to female reproductive reality. A law recognized reality first, then applied protection. And that order is essential. When recognition collapses, protection becomes performative. And this is my compression line for the first point. Before 2013, the law did not need to invent women because it still recognized women. Viewers, point number 2, the ideological category, the ideological genealogy. The deeper shift began before the legal amendment. It began in ideas. A new ideological premise increasingly entered public institutions. That biological sex could no longer be treated as the governing reality of male and female identity. Under this framework, identity became elevated above embodiment. Subjective self-identification began receiving increasingly institutional authority. Biological categories were reframed as restrictive, oppressive, outdated, or insufficient. The law was slowly pressed to move from recognizing reality to validating identity. That shift appears compassionate on the surface, but law cannot operate only on emotional intention. Law must resolve conflicts. And sex and gender identity are not the same kind of category. Sex is biological. Gender identity is internal. Sex is external, externally observable. Gender identity is subjectively declared. Sex is materially relevant to privacy, pregnancy, sport, prisons, medicine, safeguarding, and body vulnerability. Gender identity concerns personal identity, dignity, and social recognition. Both may involve human beings deserving respect, but they cannot be treated as interchangeable without consequence. The consequence that we're seeing in Australia today, the whole world is watching it. Once identity is granted legal force inside sex-based law without preserving biological sex as the controlling category for female protections, collision becomes inevitable. The conflict does not require hatred. The conflict only requires incompatible foundations. And that is what Parliament failed to properly resolve. The legal crisis began when identity was given power to compete with biology inside laws built to protect biology. Viewers, teaching point number three. The 2013 legislative insertion. The 2013 amendments were presented as equality reform. The public language was inclusion, protection, fairness, and anti-discrimination. But the legal effect was deeper. Parliament inserted gender identity protections into sex discrimination law without adequately securing the legal meaning of biological sex for women and girls. That was the architecture defect. The issue is not whether all Australians deserve basic dignity. They do. The issue is whether Parliament can protect one category by destabilising another. When gender identity was added, Parliament needed to answer the central rights conflict question. When biological sex and gender identity collide, which category governs female-only spaces, services, sport, prisons, shelters, privacy, and safeguarding? And that question was not resolved with sufficient clarity. Instead, the law created ambiguity. And ambiguity in rights law does not stay neutral. It just does not stay neutral. It gets operationalized. Institutions begin guessing. Bureaucracies begin overcorrecting. Courts begin litigating. Citizens begin carrying the cost. Women are then told to defend boundaries that Parliament should have already protected and stripped, and that is the failure. Not simply that law changed, but that the law changed without preserving the category it was already meant to protect. It was already protecting it. The conflict was not accidentally discovered in court. It was structurally planted in the new legislation of 2013. Viewers, teaching point number four. Degeneration chronology. Degeneration chronology. The damage did not appear all at once. That is why many people missed it. Stage one was language. Definitions changed. Words expanded. Categories blurred. Stage two was bureaucracy. Government departments, institutions, schools, sporting bodies, employers, service providers and digital platforms began adapting their policies to the new legal atmosphere in Australia. Stage three was compliance fear. Organisations became afraid of being accused of discrimination. Many began prioritising identity recognition over sex-based boundaries because legal risk had become unclear. Stage 4 was boundary erosion. Female-only spaces began losing certainty. Sporting categories became contested. Women's services became legally anxious. Prisons and shelters entered policy confusion. Language itself became policed. Stage 5 was conflict. Women who objected were treated as the problem. Service providers who maintained sex-based boundaries became legally exposed. Public debate hardened because ordinary people could see the contradiction, but institutions kept renaming it. Stage 6 was litigation. The courts became the arena for questions Parliament should have resolved. Citizens were forced to fund and endure legal battles over definitions that should never have been unstable. They should never have been altered. Stage 7 is where Australia now stands. Political repair has begun because the consequences are no longer theoretical. The private burden has become public controversy. And what began as wording became policy. What became policy became coercion. What became coercion has become litigation. Viewers, teaching point number 5. Point number 5. Human harm architecture. The real test of law is not how elegant it sounds in Parliament. The test is what it does to people. Consider the teenage girl in a change room. She's told the space is still female only. But the word female no longer gives her certainty. Her discomfort is reframed as intolerance. Her privacy becomes secondary to another person's identity claim. Consider the female athlete. She trains for years inside a category created because male and female bodies are not interchangeable in sport. Then she's told fairness must yield to inclusion. Her loss is treated as emotional inconvenience rather than sex-based disadvantage. Consider the domestic violence survivor. She enters a refuge seeking safety from male violence. The entire purpose of that environment depends upon trust, sex-based privacy, and trauma-sensitive boundaries. And if the law cannot clearly protect that boundary, then vulnerability itself becomes legally exposed. Consider the female prisoner. She has no ordinary power to leave. If sex-based placement becomes unclear, then the most powerless women are forced to carry the most extreme consequences. Consider the female business owner. She creates a female-only service. Then the law places her at risk for maintaining the very boundary her service was designed to provide. This is not abstract. This is the human cost of category collapse. When the law destabilizes the word woman, ordinary women are forced to carry the consequences in their bodies: businesses, safety, privacy, and speech. Teaching point number 6. Point number 6, viewers. The Giggle Recognition Event. The Giggle case became nationally significant because it made the hidden legal conflict visible. For years, critics warned that gender identity protections could collide with female-only spaces. Many were dismissed. Then the issue appeared in court. A woman-only app became the battlefield for a much larger legal question. Can biological sex remain operative in a female-only space? That case became more than litigation. It became recognition. Australians suddenly saw that the debate was not theoretical. It had absolute practical consequences. A person could build a female-only space and then face legal consequences for applying a female-only boundary. And that's why the case matters. Not because one app defines the nation, because one case exposed the structural instability Parliament created in 2013. It revealed that the law had not merely protected additional people, it had created a conflict between identity-based inclusion and sex-based protection. Once that conflict became public, Parliament could no longer pretend the issue belonged only to activists, lawyers, or online commentators. It had entered national, international reality. Giggle did not create the crisis. Giggle exposed the crisis Parliament had left unresolved. Teaching point number 7, viewers. Point 7. Constitutional escalation. This issue is larger than one statute. It concerns the credibility of law itself. A legal system depends on stability and stable categories. If Parliament can make women legally unstable, then every protection attached to woman becomes unstable. If female can be attached from biology, then female-only protections lose their foundation. If sex becomes administratively negotiable, then institutions no longer apply reality, they manage ideology. The constitutional concern is not merely written text. It is deeper, viewers, listeners. Can citizens trust a legal system that punishes them for recognizing observable reality? Can courts protect rights when Parliament destabilizes the categories those rights depend upon? Can women rely upon protections if the protected class itself becomes uncertain? Can public trust survive when ordinary language is redefined by institutional force? And this is where the debate moves beyond policy. It becomes a question of lawful order. Law is meant to discipline power under reality, justice, and reason. But when law claims authority to redefine foundational human categories, law begins behaving as if it stands above reality. And that is dangerous, because once institutions no longer submit to reality, citizens begin losing confidence that institutions will submit to justice. And Australia cannot preserve rights, the world cannot preserve rights, while destroying the definitions those rights depend upon. Viewers, teaching point number 8. Point number 8, urgency framework. Delay is no longer neutral. Every year of uncertainty increases harm. Every unresolved case increases legal risk. Every confused policy increases institutional fear. Every female-only space left ambiguous increases public distrust and puts people in danger. Every woman forced into litigation proves Parliament has failed to do its work. And this is why reform is urgent. Not symbolic, urgent. The law must be repaired before more women are forced to defend reality through personal sacrifice in every aspect and respect. Before more organisations are punished for maintaining sex-based boundaries. Before more girls are told their discomfort is bigotry. Before more female athletes lose fairness. Before more vulnerable women lose confidence in refuges, prisons, bathrooms, change rooms, services, and speech. And the urgency is not panic, it is proportional recognition. When a legal defect creates foreseeable harm, delay becomes participation in the harm. Parliament created the ambiguity, Parliament must repair it, as soon as possible, immediately. The longer Parliament delays, the more citizens are conscripted into paying the cost of legislative confusion. And I'm going to say that again. The longer Parliament delays, the more citizens are conscripted into paying the cost of legislative confusion. Teaching point number 9, viewers. Point number 9, the restoration blueprint. The remedy must be precise, not rhetorical, not vengeful, not careless. The law should restore biological sex as objective, binary, and operative for sex-based protections. It should define men as adult human male, woman as adult human female, male and female by biological sex, and sex-based protections as lawful where dignity, privacy, safety, fairness, safeguarding, bodily vulnerability, trauma recovery, or female-specific service provision require them. The law should clearly protect female-only sport, female-only change rooms, female-only bathrooms, female-only prisons, female-only domestic violence shelters, female-only health and recovery services, female-only apps and associations, female-only gyms, female-only education settings where justified, and female-specific advocacy. At the same time, ordinary civil protections against unjust harassment, violence, and genuine mistreatment should remain. Restoration does not require cruelty. Where sex-based rights exist because biological sex matters, biological sex must govern. And that's not regression. That is legal coherence. Restoration, viewers and listeners, is not hatred. Restoration is the return of law to the reality it was built to recognize. Teaching point number 10. Point number 10, compensation and redress. I'm going to say that again. Compensation, something that nobody's talked about. Compensation and redress. Repairing the law is not enough. If citizens have suffered because Parliament created defective, right-conflicting legislation, justice requires more than future correction. It requires review. There should be a formal redress pathway for those who can demonstrate harm arising from legal ambiguity, institutional coercion, or rights conflict enforcement. And this may include legal costs, business losses, reputational damage, loss of employment, loss of sporting opportunity, privacy violations, psychological injury, institutional punishment, speech penalties, and costs incurred defending sex-based boundaries in the justice system and everywhere else for that matter. The principle is simple. When Parliament changes the law and ordinary citizens are forced to bear the unforeseeable cost of that change, Parliament cannot wash its hands of the consequences. Compensation must be evidence-based. It must be lawful. It must be assessed carefully. It must not be dismissed or diminished, because without redress, the state effectively says, we created the conflict, you paid the price, and now we move on. That is not justice, viewers and listeners. That is abandonment. Accountability is the price Parliament must pay when citizens are forced to suffer the consequences of legislative failure. And viewers, this is my final consequence statement on behalf of all the women of Australia and anywhere else where this unfortunate thing has happened. Australia now stands at the legal and moral threshold. The question is not whether every citizen deserves dignity. They do. The question is whether dignity for one group can build and be built by dismantling the legal protections of another. The 2013 amendments did not merely change words, they altered the operating foundation beneath women's rights. They turned biological sex from a stable legal category into a contested administrative battlefield. They forced women, service providers, organisations and citizens to fight through courts over realities Parliament should have preserved. Now, the repair must be equally serious. The law must restore biological sex. Female protections must be made clear. Women's privacy, dignity, safety, sports, services and speech must be protected. And those harmed must be reviewed and, where proven, compensated. Because a society that punishes people for recognising reality does not become more compassionate. It becomes more coercive. And a legal system that destabilises the meaning of woman cannot honestly claim to protect women. And this is my closing statement. Reality does not become unlawful because Parliament forgets how to define it. I'm Dr. J.W. Ayub, theologist since 1994. Like and subscribe to help the channel. Comment to educate me and share the video to help somebody else.